Hi, guys. My name is Avalon. I'm an immigration attorney here at Manifest. Thank you so much for joining us today for this webinar. A little background about myself. I have been a practicing immigration attorney for 10 years now. And when it comes to immigration, I have experience in all three areas. So that's employment-based visas, family-based visas, and also removal defense. And so I'm just going to give people another 10 seconds or so to come in, and then we'll start answering the questions. But again, thank you so much for joining us today. So one of our first questions today is about the factors that determine an EB-1A success. Is it purely the candidate's credentials, or do the attorney's strategy and experience matter as well? And so this is a layered question, and I do want to indicate that, yes, you do have to pay attention to what the regulations say. Of course, you know, you're submitting a strong application where there are 10 criteria. You submit evidence for at least 3 of the criteria, but also pay attention to final merits. And the final merit, which is the second prong that we must address for a successful EB-1A application, is where you really see the attorney's strengths, credentials, and strategy matter. This is not the time or the season to really try to do it yourself or utilize the services of AI to help you prepare a petition. You really need to try to speak with an attorney to best strategize a winning strategy for yourself and for your case. Why? Because you don't want to sound or look like just any other applicants. And you also want to make sure that when you're presenting your documents, it's not just a document dump. What I've been telling some of my clients, and even some consultations I conduct, is to make sure that your work actually makes sense. And what I mean by making sense is that you are providing a roadmap and showing exactly how all of your achievements connect with your other achievements and what has led you in this professional journey that you have taken over the last 10 plus years or so, what has led you to now becoming this person who has a sustained acclaim and is now at the top of your field. So in short, yes, the attorney's strategy does matter, and their experience matters as well. I love all attorneys, all of my colleagues in the industry, but someone, you don't want to go to a tax attorney to help them file your EB-1A application. You need someone who does have the experience and who's seen the RFEs, they've seen the denials, they've seen the noise of intent to deny, and they have the experience and the track record of success to help you really have a fighting chance when it comes to applying for this visa. That's a great question. How will the potential gold card affect the new NIW category and priority dates? That's a great question. One thing to keep in mind, the gold card has not been officially implemented. Things are still in flux and things are still being worked out. And so right now we're trying to wait and see exactly how it's going to be rolled out. I would not put too much stress on a potential gold card and what the potential impact may be on the application, on a potential NIW application. I do want people to really just focus on where they are today, the current rules and requirements for today, and then draft your petition with today's rules and today's guidelines. When it's actually implemented, if it actually does become implemented, then we'll address that accordingly. But right now, as it stands with an NIW petition, of course, you have the foundational educational requirements and then the 3-prong test. Is your proposed endeavor Does it have substantial merit and national importance? Are you well positioned to advance the endeavor, meaning your background and your experience? And then last but not least, if on balance, it is of benefit to America to waive the job offer requirements and grant you this visa. So let's just focus on that if you do have an NIW, a potential NIW case, so that we can present that and work on really drafting and crafting a strong petition for you. I see a question here about the current status of the lawsuits challenging the $100,000 fee. Specifically, do you expect a preliminary injunction or a pause to the fee before the end of December? That's a great question. Yes, there are some recent challenges. Most, notably, the Department of Commerce, the Department of Chambers of Commerce has a lawsuit against, this fee being implemented. And so we're waiting to see exactly the outcome. Of course, the administration has pushed back and they are, trying to uphold the fee being implemented and charged to applicants. Do I see an injunction or a pause in the fee before the end of December? Not really, because remember, it is still holiday season. Many departments are operating on skeletal crews and staff, and so I don't think something will happen before the end of December. But it is a very key area for us to maintain and keep an eye out on. The next question is, if I do not have a job or a business in the US as of now, can I still apply for a visa and use that as a way to get there? So I would like some more clarifying information. Number one, so I do assume that you are abroad. One of the easiest ways to enter the country is for you to have a visitor's visa. But remember, with a visitor's visa, you are not allowed to work. If you're entering on a B2, and keep in mind, every consulate right now is really stressing and trying to ascertain your intent when you are applying for a visa. That is key. And they are highlighting that and stressing that more so than usual. So if you are entering the country with a visitor's visa, a B2, the purpose of you entering is strictly, purely, solely tourism activities. A B1 does allow a little more flexibility in that you can engage in business-related activities, but you are still not allowed to work, and you cannot earn money while you're on a B1 or a B2. So if you don't have a job or a job offer or a business in the US as of now, the best way to enter the country is going to be a visitor's visa. But if you do so, keep in mind your expiration date on your I-94 and whether or not you would be able to have enough time to apply for a visa and have that change of status be approved before your B1 or B2 expires. Someone is asking, H-1B was approved in 2023 and renewed in 2026. Planning to have the first time stamping in India in March 26. Given this, how long would the visa be valid for? Will I have to get a new stamp after renewal? So the stamping, is required if you do want to have, frequent travel in and out of the country. So the first stamping in March of 2026, that stamp is only going to be valid until the end of that visa approval. So just keep that in mind when it comes to the timing of when you are going to be going for your stamping, because they're not going to give you a stamp with a validity date beyond what you already have a validity date for, okay? What is the typical processing time you are observing for NIW standard petitions, non-premium? Unfortunately, I don't have a good answer for you. It's very, very long. Typical processing times are a year, and I've seen people wait as long as 18 months without premium processing. So if you have a valid status and you don't have the finances for premium processing, then, filing with regular processing is probably going to be the better option for you. Just keep in mind that you must maintain a valid status while you are waiting for the adjudication of your NIW petition if you're filing it with regular processing. Okay. If my salary in my current role satisfy high salary criteria, and if I get promoted, I won't satisfy this criteria. I'm not sure of this question, but this is an important, if this viewer could probably clarify that question so I can better answer it. But let me say this. When it comes to the high salary criteria, you want to present enough evidence in your EB-1A specifically, your EB-1A application, that you have a high salary as compared, number one, and not only in your geographic area, but also compared to other individuals at your job. So if there are 1,500, senior software engineers at your job, are you commanding a high salary as compared to them as well? It always looks great if you get a promotion and a salary increase. But if your promotion does not come with a salary increase, rather a decrease, that is some of the ways in which an attorney especially can really help you in crafting a compelling argument as for high salary, whether there was an increase or a decrease or an outlying year where you didn't make as much money, maybe you didn't work long enough hours in that particular year. So that's something I would ask you, or recommend that you speak with an attorney about specifically, so you can come up with the right strategy and how to present your salary information. When on concurrent H-1B, what is the minimum hours to work for a second employer? How should concurrent H-1B hours be specified in a petition if the hours vary week per week from 1 to 10 hours depending upon the employer? So with this concurrent employment, it sounds more like you're working as a consultant or per case, and it's not a full-time job. If you can add another comment about whether this is a full-time position as well. But the minimum hours, I will just say, or the hours that you are working when you are on an H-1B, is really going to be contingent on what's noted in that LCA. Okay, that LCA is the standard. And so your job site must be noted in that LCA, the minimum salary must be noted, and then your employer must make sure that you're taking the steps necessary to comply with that LCA, because if there is an audit that is issued on your business, on that employer, even if someone comes and says, okay, well, where's the notice of filing? You must make sure that it is present and there. So I will say ultimately it's going to depend on what is noted on the LCA. This is a good question. I have an opportunity to write a book and earn from its sales. I'm on H-1B. Can I earn from my book as a side hustle? Now, everyone or most people on H-1Bs know that you must maintain valid status. And the H-1B is very strict as to what activities are allowed or are not allowed as an H-1B visa holder. And so the key here in this particular question is side hustle. Now, your side hustle income, one, has to be reported, because the IRS is very insistent on declaring all sources of income. And so writing a book, publishing a book is now leaning more along the lines of this is income. And so I don't believe you're going to be able to earn sales or earn from that book being sold as a side hustle because you were on an H-1B. Now, if you were on an O visa, for example, and you wrote books, then that would allow you to also to more easily be able to recoup some sales, some money from those sales. So just make sure you're paying very close attention to what your status is and what the requirements are when it comes to earning an income. NIW has been pending since last 13 months. That's on average. If you did file with regular processing, you're right there in the middle, year to 18-month time frame for a regularly filed petition, NIW, to be approved. What would you suggest at this time? Giving a premium might lead to a request for evidence, as officers might not be reading the petition carefully. That is a common misunderstanding and misperception when it comes to premium processing cases receiving more RFEs than not. Understand this: a request for evidence is issued when the officer needs additional information to make an assertion or decision on your application. A premium and filing a case with premium processing only technically speeds up the issuance of that RFE. So you can continue with your case being filed with regular processing, and you may still receive a request for evidence. Just because your case has been there for 13 months doesn't mean that that USCIS adjudicating officer has been looking at your case every day or every other day for 13 months. It simply means he or she has not gotten to your case yet and is still pending to be adjudicated. If you are looking for a faster decision and you don't want to wait, another 5 or so months, then you may want to think about upgrading your processing with premium processing, which is allowed. You can just have an attorney file the I-907, or if you self-filed, then file the I-907, pay the additional processing fees for premium processing, and you'll get a decision in 45 business days. For the EB-1A, it's 15 business days, and for the NIW, it's 45 business days. Thank you for providing the updated question. So the question is, if my salary in your current role satisfy the high salary criteria, but if you receive a promotion and you no longer satisfy that high salary standard, can you use your past salary to satisfy the high remuneration for O-1 visa? Yes. For O-1, they're looking at whether you have commanded in the past, you currently command, or you will command in the future high salary or significant remuneration. So for that O-1 visa, yes, you can definitely use your high salary from the past employer to satisfy that criteria. Thank you for providing the additional clarification. USCIS I-140 processing times are degrading. Can you give some idea on how the service center times and functionings have changed under new SCOPUS classification for all centers? Again, they are, number one, every service center has a different processing times. So that's the first thing to keep in mind. Texas is notoriously busy, right? Vermont, less so. And so where your petition ends up when you file, whether with regular or premium, will play a factor in how quickly your case is adjudicated. Now, premium processing, yes, those officers at busy service centers do have to make a decision much faster, and they may be under the gun. And yes, you can probably argue that, they have to make a decision. They haven't made a decision yet. So here comes an RFE or a NOID. But service center timelines and their functioning, they're always going to be in flux. They are always going to depend, number one, on the time of the year. Right now is around Christmas time, holiday season, end of the year timelines. And so some people, they might be busy. They might not get to your case as quickly as possible. And if your case has been filed with a regular processing fee, then yes, you are going to be impacted more so than if you filed with premium processing. Does being an author make your petition stronger? I found out I qualify for 6 of the EB-1A criteria, and I wanted to launch my book before considering submitting my petition for EB-1A. Please advise. So remember, when it comes to your EB-1A, you must satisfy at least 3 or minimum of 3 as of now. There has been talks about that changing, but as of right now, it's still 3 of the 10 criteria. When people say they qualify for 5, 6, 7 of the criteria, my first question to you is, well, how strong is your evidence? So number one, let's make sure that we are submitting evidence or for certain criteria where we have strong evidence. So now when it comes to the authorship category, let's say in this particular question, is your publication of that book your only authorship that you have to submit as evidence, or do you have others? Because if it is your only piece of evidence for the authorship criteria, I would rather you submit that as part of your final merits than submit only one piece of evidence for that particular criteria or any criteria. Okay, unless you're now saying that you are a published author, you're a New York Times bestseller, there are 15 million copies of your book in circulation, if it's a technical or scientific book, that book has been cited 2,000 times, that's different. But if at the time that you're filing your application, you have one book in that particular category, then that's going to then water down the category that you're submitting for and may even open the door to a potential request for evidence. So I would want you, before you make a decision as to whether you publish the book now before you submit your EB-1A or not, really further assess whether or not all of your criteria are strongly met. And then make an assertion as to how you're going to use that particular publication to support the overall strength, not only when it comes to the criteria for EB-1A, but also when it comes to the final merits analysis that you have to submit additional evidence for as well. What is a good way to contact USCIS to seek clarity on a pending NIW application? When you say clarity, are you speaking or referring to how long it's been pending? Then you can try to call their 1-800 number. My little workaround, because when you call the number, you will get the automated system. And so my little workaround is for you to continuously not only just ask to speak to a human being, but there's a very key phrase that you say, service center appointment or appointments. Then you give your receipt notice, a number, and then you keep saying appointment, and then eventually that will transfer you to a human being. But when you contact USCIS with their 1-800 number, that initial person that you speak with will only be able to tell you how long your application is pending. Or if it's in normal processing times. And NIW petitions, as I mentioned before, they do take up to 18 months plus or minus to be adjudicated. So they're not really going to be able to provide you with much information, unfortunately. And so while you may be anxious and nervous, especially in light of some recent news, and just waiting to see if there will be even additional news that come out when it comes to immigrant petitions, unfortunately, there isn't any more information than whether or not your case is still within normal processing times that someone on the USCIS service center, service board will be able to give you when you do contact them. Next question is, what evidence is required to showcase experience that you had in the past in India? So that's going to depend on what criteria you're trying to submit for. But in terms of past experience, you want to make sure that you have, if it's an employer, an employment verification letter, any type of publications you want to, or press and media coverage, you want to be able to provide, the medium it was published in, online article, print media, the date it was published, the author it was published, and if anything was not published or presented in English, it must be accompanied with a certified English translation. If it comes to if you want to include a recommendation letter from one of your former bosses or supervisors, or even a letter from your former dean, let's say, or chair of your department when you were studying abroad, they just make sure that their letters include key details and information about what you have done and what your experience is. So ultimately, everything must be dated. Everything must have clear evidence and proof of what you are submitting. So let me just take a moment here to speak about recommendation letters. The recommendation letters that people provide are great, but keep in mind they should not have too much flowery language. It must be specific to you and to your experience. With those recommendation letters, you always want to be able to provide additional corroborating evidence. So if your recommendation letter is speaking to your past experience where you decreased, costs by 1,300%, or you increase efficiency by 52%, where is the corroborating evidence? Where is the company documentation? Where are the emails, the PowerPoint presentations? Where are the slide decks you created that shows with your name on it that this is something that you did? So with past experience, the information has to be dated, or the recent letter to corroborate what you're saying must include specifics. And then you must also provide the additional corroborating evidence, slide decks, PowerPoint presentations, newspaper articles, you were quoted in a magazine, things along those lines to corroborate what those letters are claiming about your work. The NIW petition rejection rates are extremely high. Further to this, the processing times are increasing manifold. So is it futile to file for the NIW until 2028? So let me break this down and say, number one, the first part of your question, when you say rejection, are you talking rejection or denial? A rejection occurs when an applicant has filed a petition and something was wrong in the initial review of that petition, and then the service center returns or rejects the filed petition back to the applicants, and if they use an attorney, the attorney. For example, if the fee was wrong, or if a particular application was unsigned, if you use an attorney, if the G28 was unsigned, or if you use electronic signature, or if it was undated. Those are the typical instances where we will see a rejection. Or less common now, because people are paying attention, if you use the wrong edition date of the form. That's when cases are rejected. However, if you're speaking about denials, then you're talking about or looking at when you apply for an NIW, you first received either a request for evidence or a NOID, and then the case, after responding to that RFE or NOID, then the case was denied. So I don't want us to confuse the use of the word rejection versus denial. They mean very different things. So and yes, processing times are long. I would rather you, though, submit a strong petition that you've worked on diligently, also with an attorney. Now, it's very expensive to apply for these visa types. So, it may not be the best scenario for you to apply on your own and risk the increased chance of receiving a request for evidence or a NOID. Apply now. If you're ready to apply now, apply now. Yes, the processing timelines are long. However, you also have a priority date on that receipt notice that may come in handy in the future. And also your case is there being adjudicated. So I don't think the long wait time should be a deterrent for you as to when you apply for a visa that you on the surface look like you are qualified for. For EB-1A, O-1A, what would be considered a high salary for an electronics engineer in the Bay Area based upon your past experience or interactions? Is 150 eligible? So not only are you looking at your geographic region where you are putting your zip code and see what is the average salary, you're also looking at your company as well. On average, looking at other electronics engineer, what is the average salary you're making? So when it comes to this, what I've been asking my clients to do recently is obtain an HR employment verification letter, where that letter on company letterhead indicates whether or not your salary is high, is significantly higher than other people on your level as well. That has been working well for me with some of my clients, improving that high salary standard as well. So first, confirm, just to reiterate, to confirm with your geographic area as to what your salary is. And second, confirm with your employer and receive that HR verification letter so they can provide a letter for you indicating that you are in the top 5%, top 3%, top 10% of other individuals who have a similar job title and job responsibilities as you do. Do we need to exit the US when we renew our H-1B and H-4 visas, or can we say as long as our visas are renewed and valid, and only have to stamp when we travel out the country? Yes, if you have no plans of traveling, and by renewing your visa, I mean, I'm going to presume you mean by extending your visa. So long as you are eligible and you have enough time on your H-1B visa, yes, you can continuously apply, file for, H-1B extensions while you are in America. And you don't have to leave and to get a stamp until you travel out of the country. That is correct. In light of the government shutdown freezing LCA filing for more than 30 days and the H-1 and the $100,000 fee for H-1B consular processing, do you have any examples of how USCIS may handle a visa transfer from a pending B-2? So I presume that pending B-2 was probably filed to bridge the gap before an H-1B was filed. If I'm misunderstanding, please, include a clarifying comment in the questions. So yes, so the government shutdown, which lasted over 40 days, I believe, was abnormal, right? It was such an aberration. It has never happened for that long before. And so, how they may handle a visa transfer. Well, of course, once you have now the Department of Labor has reopened and people are able to file for their LCAs. And so now that you are applying for your H-1B H-1B transfer petition, and technically changing your status from a pending B-2 to now an H-1B, so long as I make sure you have all of the other requirements ironclad. The LCA has been certified and is now signed by a signatory at the company or at the employer. Your job, your pending job or prospective job is meeting all of the minimum requirements. It is a specialty occupation. You're getting at least what the salary indicates for prevailing wage. They're going to adjudicate it as any other H-1B transfer applications. So just keep that in mind. My only concern would be if you fell out of status completely and then filed a B-2 application. At that point, do speak to an attorney as to exactly what happened to make sure you were in status and you never fell out of status, even after the grace period. If you did change jobs, that's 60-day grace period. So just make sure that you did not fall out of status completely, then try to file for a B-2 application, and now you're going back to filing for a change of status H-1B transfer application. That would be my only point of concern for you to make sure you speak to an attorney about. I got my H-1B visa in 2006 and didn't work on that, got expired. Is there any way I can make use of that approval for a priority date? Is the LCA still valid? I would want you to speak to an attorney to really go through exactly what happened there, why you did not work on it. Also, are you saying that you received an H-1B visa approval in 2006, or did you receive a perm in 2006? I'm unsure of the question. So that one I would want you to speak to an attorney about as well. If high salary and judging criteria are not applicable to my case, which of the other 6 criteria you suggest emphasizing on priority basis to strengthen the O-1A petition? That all depends on your experience. What do you have experience in? And what do you have experience in that is well documented? Okay, so if you don't have high salary or judging, what about leading or critical role? Do you have experience there? What about authorship? Press and media coverage, either you, and if you, for example, with press and media coverage, if you yourself were not specifically discussed in the media, however, your company and something that you specifically worked on was discussed in the media, that can also work to awards satisfying that criteria as well. So it all depends on your resume, your body of experience, the work that you've been doing to really examine exactly what you should be submitting for. Remember, everyone's application is going to be different because it all boils down to your experience and the areas of your expertise. Okay, so if I do not have a job or a business in the US as of now, can I still apply for a visa and use that as the way to get there? I mean, to get to the US and work or start a business? Well, you need a pathway to enter the country. And so if a family member is not filing for you with a family-based visa application, and you don't have a job currently, so you won't be entering on an employment-based visa, such as a TN, H-1B, L, or an O, then you would need to enter on a visitor's visa, or maybe even a vocational visa such as the M1 visa, student visa, F visa, a trainee visa, like a J1 visa. You have to find a legal way to enter the country. And then starting a business in America will help you look at what you're able to do, of course, but the first path is how you get here. So the easiest way is going to be to apply with a visitor's visa for you to come into the country. However, you want to make sure that you don't work on the visitor's visa. Now, the EB-1A, you are allowed to enter if you have enough international experience. And so, have you tried to assess your eligibility based on any international experience you have, and then have a consular processing petition for an EB-1A or an O-1A? Have you incorporated a business or have plans to incorporate a business and work for yourself? And if that's an option and you have a legitimate business idea with a business plan, you can probably try for an O-1. But you are going to have to really strategize with an attorney for the best possible way to get here. My F1 visa is expired, but I enrolled into a new school, which keeps my status valid. Okay. I am planning to petition for the O-1A visa. Can I apply to change of status, or will I have to go to consular processing? So long as you are in America and you have a valid visa, you can apply for a change of status petition. The key is being in a valid status. And so if you are holding a valid status with the new school and your I-20 is valid, has not expired, and you are following all of the requirements for your enrollment. So for example, if you are supposed to be enrolled full-time in school, but you've only been going part-time, then you're not maintaining the requirements or meeting the requirements for that I-20. So just make sure that you are maintaining valid status. And once you're maintaining valid status, then you can safely apply for a change of status petition from an F1 to an O-1A. And because the O-1A is a dual intent visa, there will be no questions as to your immigrant intent when you are applying. Can reference letters from early stage startup CEO stating volunteering contributions to raise funds and get projects be used to meet the O-1 EBA awards criteria? Startup is not the employer and has no earnings yet. That's a little tricky. So typically some founders and startups and entrepreneurs, when it comes to the awards criteria, they will use their funding. If they receive venture capital funding, if they completed some accelerator and they were able to get funds that way for their startup, they can use that toward the awards category. Again, working, with an attorney to properly strategize how you're presenting that information. The difference here in this particular question, though, is that you volunteered. So you are not an employee of that particular company or that startup, and the startup currently is not your employer and has no earnings. That becomes tricky. It may not be able to qualify for the awards category Definitely not for the EB-1A. However, for the O, it can go probably more towards the comparable evidence section, where you're not really meeting a certain criteria, but you do have some evidence to show that, here's something else that I did that demonstrates how qualified I am, how extraordinary I am. So it may work, but I would want to know exactly the details and the depth to which you contributed to that your volunteering contributed to them to raising funds, and then how much funds. But you not being an employer of the company while you were doing that work is a little tricky. So speak to someone about that. What is the minimum publication reviews do you suggest to satisfy the EB-1A and the O-1A judging criteria? So I see some EB-1A and O-1A cross questions, and although the criteria are similar, remember the standards are very different. And we can see that with the approval rates for both an O-1A as compared to the EB-1A. And so I don't want us to conflate the two visas when we're examining the criteria that are required for this particular visa. So when it comes to the judging criteria, how many judging or publication reviews you suggest? I mean, it should be more than 1 or 2 or 3. Okay. Safest bet, minimum of 5. But the more you have, the better. And the more you have that expands, that's over a period of time, looks better as well. Because you never want to present an application that looks as though you just padded your experience right before you submit it. If you have a detailed history where you've been doing these reviews, maybe 1 a year over the last 10 years or 5 per year over the last 4 years, that looks better than if you do 10 judging or 10 publication reviews in the month before you filed. So I would say a minimum of 5, to be concise. I'm a businessman and have led many businesses across technology, consulting, and media. Does this tell a compelling story? Well, it's a good start to a story. And so if you're applying for the EB-1A, it's a good foundation. But, some additional questions to consider would be, okay, well, if your first business, let's say, was in technology, how did you come to wanting to start that business? What led you to then transitioning from technology to consulting and then finally to media, or whatever the trajectory was? You want to be able to explain why you went from one industry to another industry, and then also expound upon the different achievements you've had in these particular companies, in these particular businesses, and how. And then this is the key, especially when it comes to final merits and even writing your statement of intent. How does this experience in these 3 different industries now lead you to being this person? How did it now develop you being so extraordinary? And then what sets you apart? Right? You have these experiences, you have multiple businesses that you started, you ran, maybe you took over, you took it to another height. Okay, so now you have this niche experience, because many people don't typically go from technology to consulting and to media, or have any 3 of those in their background. So you have to now be able to come to draft and craft a compelling story to explain that, and then focus on the strongest areas in your background, so that when you are telling your story and applying for the EB-1A visa, it makes sense. Okay. Are you currently handling EB-2 or I-140 cases? I have a full-time tech job and I want to change my immigration status. So full-time tech job, firstly, what is your current status? What is your current visa? How much more time do you have on your expiration, on your validity date? And then, what is your background? Do you have a job offer already lined up to change visa types? Those are the type of the background questions I would need to know first. But of course, don't put too much information in the chat about, personal information. speak to someone privately about that. Of course, if you are currently in a visa status, as I mentioned before, you do have the option to apply for a change of status petition so that you can change to another visa category. So long as you meet those requirements and apply properly, that is always an option. CAP exempt healthcare worker here. Thank you for your service being in the healthcare industry. Saw your Reddit note about nonprofit nurses getting NIW after the $100,000 rule. Is that real? And is any relief for healthcare employers likely early next year? By relief, do you mean whether or not the fee would not apply to you? What type of relief are you speaking about? But yes, our notes on Reddit are real. NIWs are not, NIWs, one particular visa category, the $100,000 rule applies for H-1B visas, so they're not being adjudicated concurrently. So just keep that in mind. But I would like to know what type of relief you are speaking about specifically. I once received a U.S. University Scholarship Reward for an MS, but I didn't pursue. Do you think this reward could count toward the O-1 criteria for awards? I understand in general it is likely that it would not. I would advise no. So when it comes to the award categories for O-1s and for EB-1As, typically internal type awards, so Employee of the Year Award, grants and scholarships won given by your university or your college do not rise to the high enough standard as required for the O-1A or even the EB-1A visa applications. You want to make sure that if you're submitting for that particular visa category, that criteria, that your awards were more on a public scale where there was more competition, so to speak, and then you won out for all of that, the competition there. Internal awards typically, such as a scholarship, merit, even though it may have been merit-based, does not rise to that level. Next question. If someone has an existing NIW petition that is pending, how much is he supposed to pay to upgrade to premium? Is he supposed to make a top up or pay a new fee? So if you want to change your currently regular processing NIW petition and have it be premium process, it's one additional fee of $28.05. How to deal with recency for EB-1A. Not sure what you mean by recency. I have a strong judging and strong scholarly articles, but most of it falls, recency, I understand. But most of it falls in 2025. Listen, if you started building in 2025, then you started building in 2025. I don't want my earlier comments to deter you or anyone from applying if the majority of your evidence was given in 2025. That's fine. How do I, as an attorney, deal with it? Well, I like to see and demonstrate if you were invited or if you were requested, if you were sought out specifically, and then argue that your experience and your expertise and your extraordinary abilities is what allowed you to be sought after more recently for these particular judging. It is not a negative. There's just a specific way or the best possible way to frame it so that it's looked at and viewed at in the best possible light. How can I start preparing in the right direction from my undergraduate years to have enough time to collect evidence to help me apply for an O-1 visa after graduation? So that's all going to really depend on the industry that you're in and also what you've been doing thus far. If you are currently still in your undergraduate years, so I would, speak to one of your professors. They always have information and insights on associations you can join, authorship opportunities you can partake in, even some insights if you have a mentor that you're close with in your undergrad years about jobs that you can sign up for. I will say this for all applicants, O-1A and NIWs, EB-1As, if you are looking to also gain a lot of experience, look into these associations, because even if you join as a regular member, in the beginning years of your professional career, there are always opportunities to build and to grow, and so attend the conferences, look into, having papers submitted, see how you can become involved in those associations as well. Because the more you attend those conferences, the more people begin to notice you, the more you can share your views, because when it comes down to getting expert opinion letters, you can then tap into the network that you've built at these associations. A question regarding H-4 EAD, because auto renewal will no longer take place for H-4 EAD. How can I ensure that it is renewed and obtained in time? Well, don't try to apply for the renewal 2 weeks before the expiration date. You want to make sure that you're applying, that you have enough time. So maybe try to look into applying 4 months out, 3 months out before the expiration date. So at least you have a receipt notice while you're waiting for the visa to be the visa application to be adjudicated. Okay. I entered the US on an H-4, received an H-1B approved, but never worked. Okay, and did not apply for a social security number. My existing I-94 reflects H-1B valid until 12/31/2025. Can I apply for a change of status from H-1B to H-4 without leaving? Yes. So long as your spouse is currently maintaining their own H-1B status, then you can apply as a spouse to change your status from H-1B to H-4 without leaving the country. Now, of course, make sure you're submitting the proper corroborating evidence and supporting documents such as your marriage certificate, and then documents to show that your spouse is maintaining their own valid H-1B status, such as pay stubs, job offer letter, and H-1B approval notice as well. How long before one can see any movement on the $100,000 fee case from the courts, asking so as to understand when should I plan to travel to the home country? H-1B renewal is in September 2026. Unfortunately, the wheels of justice move at its own pace, and things often take a lot of time once it's in the court system to reach some sort of resolution. And then with the option for there to be appeals as well to higher courts, things can go back and forth for a while. So when do we expect to see much movement? If I had a crystal ball, I can give you a better answer. But right now, we're just waiting on the courts to make a final decision. If you were to file an NIW petition while the employer filing is pending for a year, what would be your suggestion to do with the existing NIW filing before or after you file a new one? So is the question, you already have an employment-based petition pending, so maybe your perm is still pending, and now you want to file an NIW petition? I need a little more clarification, but just keep in mind that you are able to have multiple applications pending in USCIS at the same time. So if there's already an application pending and you want to file a completely different application, you are allowed to do so. So long as you meet the requirements and pay the requisite filing fee, you are allowed to do so. Is applying during the festive season the best time, or would you consider applying early next year? You may want to apply early next year. However, do keep in mind there are some changes that may be on the horizon. There are some talks and rumors about. So rather than looking at do I apply during December or early January when offices are still on a skeletal staff system, you may just want to apply when you're ready. Okay, so don't think of who's in the office, who's going to look at my application. Answer the question, are you ready to file now? Or are you still building your portfolio? That's the more relevant question to answer. Premium, this is a great question, and often we see a lot of misunderstanding around this. Premium processing or regular processing for NIW. Are they held to different standards? No. And that goes for all cases that are eligible to be filed with premium processing. It's not held to a different standard. The government's, the USCIS reviewing officers are looking at the exact same criteria and examining your experience and your application to see whether or not you are qualified and you meet the standards. Premium processing the only difference is that you are given a decision in 15 business days, or for NIW, in that case, 45 business days. Now, the decision may not be what you like. The decision may be, here comes an RFE or here comes a NOID, but at least you receive a response from the government within the 15 business day, not calendar day, guys. They don't count the weekends when you're trying to calculate the timeline. Either 15 business days for regular, for EB-1A, or for NIW, 45 business days. Can one file H-1B amendment plus extension based upon a minor salary annual increase more than 6 months before the H-1B renewal date? So you have a salary increase. I would also want to know, because you will be wanting to file an amendment, are you changing worksite locations? Is there a nominal change or a major change also in your job description and job duties? 6 months is a good time frame to file for before the renewal date. But in order to obtain a decision quickly before that particular date, you should definitely try to apply with premium processing, just to make sure that there isn't any wiggle room with when you receive that decision. Follow-up, is O-1A dual intent? Yes, it is. Follow-up for fee relief. I believe that's for the healthcare question that was posed earlier. There may be some, so for nurses, healthcare workers, there are some humanitarian exceptions, but we're waiting for additional information about that. My brother is currently in India and holds an approved and stamped H-1B petition from last year. Okay, so this is before that particular cutoff. He previously traveled, here we go. He previously traveled to the US and stayed for about 1 week with employer A, but then returned due to health issues, and employer A won't onboard him. If he transfers his H-1B to employer B while abroad, would the proclamation $100,000 fee still apply to him, even though he has already entered the US once on his existing H-1B visa? Well, but he's going to have a new visa now with a new employer. So it's not as though he's entering with his same employer A. The key here in this scenario is that he has a brand new employer. And now, did employer B already file for him, or will they be filing, in the coming weeks or the coming months? That's something to consider as well. You mentioned about international experience. So does this kind of experience itself satisfy any of the criteria? So let me explain. Let me clarify my clarification. When it comes to international experience, you want to make sure that you're looking at the particular or the specific criteria. Which bucket, so to speak, does it fall under? Okay, past experience, are you looking specifically at leading a critical role? Are you looking at international experience? Are you looking at press and media coverage? Are you looking at authorship? Where exactly is that experience, that international experience, which bucket is it falling into? So if it falls into one of those buckets and you have enough corroborating evidence around that international experience, then that is something to consider as well. And I always tell my clients, don't discount what you did when you were back home in your home country, or if you had a stopover in London, for example, or you were in, France somewhere. Look at everything that you've done and present everything to the attorney, if you're working with an attorney, for him or her to properly ascertain and strategize how to use all of your experience. Someone is asking if I know if their profile is good enough for an O-1A. I would want to have a consultation, or you should probably have a consultation with a specific attorney so they can properly assess your experience and your background. For working professionals with master's degree in the US, how many years of work experience is required to file for the NIW? Well, that's going to come down to really how much experience do you have? Like, what have you done since you received your master's? Because remember, for the NIW, there's that tricky little second prong that some people overlook, which is, are you the well-positioned to advance this endeavor? So do you have publications? Have you been cited? Has your frameworks, methodologies, patents, is it being widely used? Are you in the press and in the media? Are you, what have you done that shows you are the best person to advance this endeavor, not just whether or not your endeavor is good enough. We're at time. I'm trying to rush. Thank you guys for bearing with me. Okay. So that's something to really consider. Not so much how many years of experience. There isn't a magic number, but what have you done in those years to showcase that that you are now the person who's best suited to advance this endeavor. And then the final, I guess this is a follow-up question. Can I apply for H-1B renewal only as early as 6 months before expiry? In 2027, I would have to apply for the H-1B renewal. I don't think 6 months is enough time to have your H-4 EAD issued. It's taking a little long. So you may want to apply for it before, like earlier than 6 months before the expiration. Okay. But I believe those are all of our questions thus far. Thank you so much, guys, for joining us today and asking these questions. Please keep an eye out for any additional updates from Manifest with any future webinars that we're hosting. And I do appreciate all of you asking your questions today. Thank you so much and take care, guys. Bye-bye.